and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. My name is Glenn Siegel. I am the special magistrate. I'll be deciding the cases brought before us today. At this time, I need to inform you that this is a quasi-judicial hearing subject to the Florida Sunshine Act. I must disclose whether I have any contact or have had any contact orally or in writing with any person who has an interest in any of the matters, and I must recuse myself from voting on any matter in which I have a personal interest or knowledge concerning the subject. In that regard, we've continued the Swenson case today. She's a former client of mine. Other than that, no other issues in that regard. You want to swear everybody in? It's going to
Yes.
At this time, all those who are going to give testimony, if you'll rise and please be sworn.
Do you swear or affirm that the testimony you're about to give today is the whole truth and nothing but the truth? If so, answer I do. Thank you.
Thank you. All right, I think we've gone through the agenda changes. What was that last one that she said?
Coach, are you going to announce the agenda changes?
Sure. Under new business, tabs C, F, K, and N are being pulled. And under tab D, sections 3-9-32 sub D and 3-9-82.1 of the Charlotte County Code are being dismissed.
Thank you. Okay, at this time we'll move on to agenda item number 6, citizen input. Anyone wishing to address the code enforcement magistrate during this portion of the meeting must state their name for the record and state which agenda items are being addressed. Remarks shall be limited to 3 minutes maximum and shall only be addressed to the myself as the magistrate. There will not be any discussion. Let me turn the podium on. Do we have anyone that wishes to make a public comment at this time? There being none, item 7, old business, we have none. Now that we're on Article 8, consent affidavits. Okay. Item.
Was that 18 or 16?
I don't have a note for either of those two.
Is it 14?
Okay, items number 2 and 14 will be considered separately. With regard to the other affidavits, those will be accepted, admitted into evidence as stated. Okay, at this time, we're going to go to Article 8 of the agenda, case number 2. COD case 02527 LL Properties. The properties are located at 12500 12540 Berntstorp Road. Anyone present on those cases other than the code enforcement?
Yes.
Okay. If you approach the podium.
Good morning.
Good morning. If you give us your name and if you're counsel, who you represent.
My name is Michael Witt. I'm an attorney with the firm of Robbins Kaplan. I represent LEOAFFAIRS Properties.
Thank you, sir. Is the county ready to proceed?
Yes.
Officer Richard Dalton, Charlotte County Code Compliance Officer. This is an affidavit for compliance.
Let me just get to that real quick. Just bear with us 1 second. I just want to get it. Okay. We have reviewed the second amended affidavit of non-compliance. Counsel, do you have any evidence you wish to offer?
Possibly, maybe just a couple of emails that I may submit, but
I'm sorry, could you speak in the microphone a little bit?
I said possibly just a couple of emails that I may submit, or I may just reference and read those into the record.
Okay. Do you want to proceed with that now?
No, I'd rather hear from the county.
Okay. Has he been provided a copy of the affidavit?
I have the affidavit, yes, sir.
All right. Anything else that the county wishes to offer?
Sean Cullinan, Planning and Zoning Official. This is back before because the property is still out of compliance with the original Code Enforcement Board order that the property owner obtained the commercial name change. Part of that was required was to bring the site up to some dimensional standards, including some landscaping and fencing. With that, we've been trying to work through for a number of, probably about a year and a half now, working through with Mr. Witt and Mr. Neff, the attorney, or Mr. Witt, the attorney, and Mr. Neff, the property owner, to come to some sort of settlement agreement in order to get it memorialized. We had sent out a draft to them in January of this year, had not heard anything back until approximately March or May of this year. And then there were a few negotiations, and again had not heard anything back until about, was it June or July of this year, and just met with Mr. Neff again last week or the week before. So it's been a very ongoing process, and it's still out of compliance from the board's original order with respect to the commercial name change.
Okay. Anything further?
Yeah. No, I was going to say, unless the county has something else.
I have nothing additional to add.
Okay.
It's basically just pictures
Counsel?
and the...
Okay, well, we're back. Yeah, we're back today because the order was entered in July of 2013, and the findings were based on two things. One, there was a trailer that was parked out toward the roadway. Debatable whether that was at the time still in the right-of-way or not. The county's violations seem to be very fluid, over the course of the last 3 or 4 years in dealing with this particular piece of property. And the other item was the fact that the county claimed that there needed to be a change in use and a certificate of occupancy obtained under Section 3-9-5, subparagraph D2. I've got that here, and I'll just read the pertinent part of that ordinance. Change of principal use. Whenever the principal use of an existing structure is to be changed, the owner, agent, etc., shall apply to the zoning official for issuance of a new certificate of occupancy. Here's the crux. Here's the hidden agenda from the county's standpoint. The last sentence of D2 says, a new certificate of occupancy shall only be approved by the zoning official when the new use conforms to this chapter. There's the rub. This property is a storage facility, outdoor RV trailer storage facility. That was approved as a permitted use dating back 27 years, going all the way back to 1987 when the prior owners got a special exception to allow for that. And that use has not changed. Not only has the principal use on the property not changed, there's been no change in use of any structure on the property. And I'll bring this up if you give me just a couple of minutes. I think it's important to understand the history because this started in 2011 with a letter from the county to LLL Properties. And they said to LLL, you can only use the back 2 acres of the property. We're going to file a code enforcement violation. You can only use the back 2 acres. You can't use the front 10 even though the special exception was for all 12. That was never brought up, never brought to the Code Enforcement Board. Really, that argument has never seen the light of day, although through the years in 12, 13, they continued to write letters. It's been in a couple of the violations about how now he can't use the front 2 acres, and then he can't go past the fence, and now he has to have a fence. The use hasn't changed. In 1987, when the special exception was adopted, the codes didn't require landscaping, buffering, fencing, screen, nothing. And what they're trying to do is enforce the new codes against L, and this is the mechanism that they're using, is saying you've got to get a CO, okay? And what they've done is, it's really kind of a cute way to strong arm him into doing that, is they cited him for not having a business tax receipt because the old one was closed out when the property was sold, and not getting a change of use CO. Well, under the code, you can see when you do that, you have to be completely code compliant with all the new codes. He doesn't have to be. And that's what the county has been doing to Mr. Neff over the last 3 years that this has been going on. Okay? So the original code violation started in 2011, and the history of this is it was continued, it was continued, it was continued. The violations all changed. Finally, in July of 2013, when this order was entered, Mr. Neff's out of state, he's up north. He had an attorney representing him at the time, not my firm, that failed to show up in July of 2013. So by default, this order gets entered on the sign about the trailer and the right-of-way. As of September of 2013, I've got email after email. That's not an issue, and that's not before you today. Okay? It remains this issue of the certificate of occupancy. Here's the best part. Mr. Neff, on behalf of L Properties, filed the application with the county in March of 2013, before this order was entered in July. And I've got emails from Mr. Dalton where he says it's sitting in zoning. Zoning won't review it. Zoning never processed it. So it's a catch-22. He's being brought up. Now the order's entered. Now they're in here trying to get fines for him not having a CO because they're trying to use that, saying, aha, we got you. Now you've got to comply with all the current codes. You've got to put in fencing. You've got to put in buffering. You've got to do a type D. You've got to do this. You've got to set back. He doesn't. And Mr. Cullen is correct. We have worked with the county now for over a year. Mr. Neff has spent tens of thousands of dollars in attorney's fees monkeying around with the county now with me for over a year, let alone prior counsel who did it, for a year or so prior to that. And in fact, just as of a week or so ago, I sent a revised draft of a development agreement where Mr. Neff agreed that he would put up a fence on the property, and the county just refused to even consider it and said, we're going on to code enforcement. We're going to try to get a fine. So, frankly, having gone back and looked at the whole history of this, I find it pretty much appalling with how this has transpired and what the county is trying to do. And I think that they were very disingenuous when they came before the board. Nobody here answering for the respondent after 5 continuances in a row. And Mr. Teseo misses the hearing, and now, bang, now we've got this order out there. So they're asking you to enter a fine and use as a hammer against L Properties for not having a CO on the property. That's fine. We'll get a change of name. We'll get the business tax receipt. We'd love to. They filed the application a year and a half ago. The county won't act on it because they're trying to get new codes, and they're trying to get the fence and the buffering and screening by using this process. And it's just not fair. It's just not right. So I would ask that you deny the relief, not award any kind of fine or a lien be placed on the property, that the county be told, hey, if he's got to refile, if the application, I think one of the emails from Mr. Dalton says to Mr. Cullen and others with the county, I think Sean Horton at the time was the community development director, hey, by the way, this application was filed in March. We've never acted on it, and it's expiring. I haven't told Mr. Neff, but we're going to come back and we're going to file something new against him, which is what they did last October and what has led us forward to today. So they need to process the application. He'll get the business tax receipt. He'll start paying business taxes to the county. Okay? If he needs a CO, they want a CO, they do it. But they can't get through the back door what it's not lawful for the county to try to impose upon this property owner, which is him to be totally code compliant with the new codes. So, you know, that's the long and short of it. Mr. Neff will try to work with the county. We tried and tried and tried. They're the ones now, as of 2 weeks ago, that has refused to even consider this, refused to look at the development agreement. That's off the table. They rejected it. It's off the table. So I don't know that it's going to be put back on the table. You know, we may be heading to a fight on whether or not they can force this guy to put a fence up and any kind of buffering and screening. That's a whole different issue. That's never, ever, ever been brought before this code enforcement board. To bring something up to say, here's a code violation that he has to be up to current codes. I think it's because they know he doesn't have to be. But they've tried to use this and this last sentence of D2 of 3-9-5 to force him into putting up a fence, putting in the type D buffer, and all of that, which he is not required under the law to do. So I'd ask that it be dismissed. You deny the relief. I'd just like to see this case closed. He'll go out. They need to process what he filed before. If he has to go back, he'll file a new one. But they need to process it this time instead of just sitting on it. And then coming back before you saying, hey, he's in violation, continues in violation because he never got his CO. But they haven't told you that for 6 months, 8 months, they just sat on it and never processed it.
Did you, you mentioned you might have some documentary evidence. Do you want to submit it at this time? And if so, I'd appreciate if you show it to council first.
Okay.
May I rebut now?
Yeah, I was going to just let him put that in, and then we'll go there.
Madam Clerk, would it be possible to get copies back of these today? Or maybe copies sent back to me? I'll show these to council, and just to identify them for the record, there's an email on May 22nd, 2013 from Rick Dalton to Sean Cullinan, copied to Sean Horton and Josh Moyer, where it says, no CO for the change of use. The application is in zoning but has not been reviewed. That's 2 months after it was filed. Then a follow-up email a few months later from Rick Dalton to Sean Cullinan, CC Sean Horton, Sandy Williamson, and Marianne Franks. As discussed with Ronnie N., it would be Ronnie Neff, the principal of Triple L, called to let me know that the trailer and sign is no longer visible from the property. That is true. But the change of use application he submitted in all caps March will be expiring September 29, 2013, and he cites a permit number. He and I did not discuss that I deferred the matter to the attorneys. So like I say, he never even told Mr. Neff that it was expiring yet. Here we are, him having filed it in March of 2013. They come back in April and say he's out of compliance, he doesn't have it. Come in July and get an order from the Code Enforcement Board that he's out of compliance, he doesn't have the CO, and they're sitting on the application. Wouldn't that have been nice to bring up before the board?
The reason for that one is because he was represented by counsel, and so counsel would be the ones to have discussions. Mr. Dalton was going above and beyond and actually should have only been discussing with counsel or having the attorney's office discuss with counsel. That is the reason for that. Now, if I may, procedurally, Mr. Witt is trying to get the case reheard. Mr. Neff was properly noticed. He went through the proper procedures. It's not the county's fault that nobody representing him showed up at the original hearing. He did not use his appeal rights, which would have been appeal to circuit court after the original notice of violation. Now, with respect to Mr. Witt's version of how this went down, the original special exception that was granted back in the mid-'80s, back prior to GIS, which would define where a parcel was or where the boundaries of where the special exception would be, The request was for the back 2 acres of the property to be used for boat and trailer and other miscellaneous storage. And it was specifically stated in the document that the front 2 acres would not be used. Well, we understand, and we worked with Mr. Neff with his first attorney back when that was going on, and that was rectified very easily. The fence that the county is requiring, there was actually a fence and landscaping which was placed on the property roughly 2 acres back by the original owner, Mr. Woody Lee. And so even though it was a code requirement, he put up the fencing of his own volition. Now, when Mr. Lee, and everything was kept on the back property, the back 2 acres roughly of the property. When Mr. Neff purchased the property, he slowly, and we've got aerial proof that was shown at the hearing, we've got aerial showing that it slowly crept up to at one point it was a couple of feet off of the trailers, and things were being stored a couple of feet off of the roadway. And that's when the code complaints came in. This wasn't a proactive violation. This was something where citizens were complaining because it was becoming unsightly. The use had expanded back from what was originally put in, and we found out that he did not have a business tax receipt. Taxes were not being paid to Charlotte County. He did not have the commercial name change, which was required. And so because of that, we started working with Mr. Neff and his first attorney and what needed to be done. And again, this was back a long time ago. We even sat on it, maybe sat on it's not the right word, but we worked with him because we were looking at the potential widening of Burnt Store Road, and we didn't want him to expend money to put in items that might be torn out in a year if Burnt Store Road widening had commenced, or if eminent domain had begun or negotiations had begun. We worked with him so that it wasn't a waste of money. After that, when we found out that the commission had decided that they were going to change the alignment to Burnt Store Road, we again engaged Mr. Neff in conversation and discussion because the code case was still outstanding, the signs were still there, the trailers were still up to basically the roadway. At that time, I can't remember if that was Attorney 1 or Attorney 2, we started the code case. The board entered a code enforcement order. That order was not appealed. That order is a valid order. The property is still not in violation, or is still in violation, and so that's why we're here for the one-day fine for the affidavit.
Counsel, you have anything to respond?
Well, yes, I very much disagree with Mr. Cullinan's representations to you regarding 8794, the special exception. It did not limit it to the back 2 acres. There was a letter initially that Mr. Lee wrote, but the application itself that was submitted says right there on it it's for the full 12. The approval was for the full 12. There's nothing in there about it being limited to 2 acres. The fence that was put in by Mr. Lee just for security. There was no landscaping there. That was no type of fencing and buffering under any kind of code. It was put in so there was a fence there and a gate that would lock. Mr. Neff is a businessman. He paid $1.5 million for the 12 acres and this ongoing business. And he didn't slowly grow the business. In 2008, when he bought it, he rapidly expanded the business. He's a businessman. And he had 12 acres for outdoor storage, and he's using the 12 acres. My point to you is, yes, that order was entered in July of 2013. I wasn't representing Mr. Neff then. I don't know exactly what happened, but it smells. And the county brought that up and got that order, and now they're back. They're asking you to, on that order, enforce a fine that on its face, the code does not require current compliance. On its face, 3-9-5 that says you've got to get a CO when there's a change in principal use of an existing structure. There's no allegation that that's happened. Okay? Where's their proof today? Oh, well, that's okay. Cows out of the barn. You never appealed it. No, they didn't appeal it, but it never should have been it never should have happened in the first place.
Understand. Counsel, I had a question for you.
Yes, sir.
When did you come on board as counsel for Mr. Neff's company?
I believe November of 2013.
All right. And prior to that time, I heard you say that you didn't really know what occurred after the attorney failed to appear for the hearing. But do you have any insight as to why he didn't show up, or why there was no appeal that was taken?
I don't know.
Okay.
I don't know. I've not spoken with Mr. Teseo, I think is how you pronounce his name. I've not spoken with him about why that didn't happen. When we came in, it was cows out of the barn. It was 30 days after the order was entered.
Sure. And did we get those two documents you wanted to put into evidence yet?
Yeah. The last part of the argument is, the county cannot say this gentleman's out of compliance for not having a CO, okay, and then him have an application pending for months and months and months. At the time they came in July of 2013, Mr. Siegel, he had an application, valid application, sitting in zoning that they refused to act on. And then they come in and say, well, he's out of compliance. He can't get a business tax receipt. You know that on that form. It's got to be checked off and signed off by zoning before you can get a business tax receipt. Zoning sits on it. They don't do it. They come in, they get an order that he's out of compliance. Now we're back saying he's out of compliance, and they refuse to process it because they're trying to use this order now that they got, illegally. Let's just call it what it is, that they got illegally from the Code Enforcement Board, because 3-9-5D2 doesn't apply. So, but that cow has trotted out of the barn, okay? But now to come back and say, well, yeah, hey, but too bad. We got it illegally, and we were sitting on the application when we came before you. There's no answer. I've got the entire Code Enforcement file on this. They did not tell the Code Enforcement Board in July, when this was presented, that he had filed the application for CO and that they were not processing it. They did not tell the board that.
If I may correct, it's not a matter of not processing. It's not approvable. It wasn't an approvable application because it required the landscaping. And again, you say D2 doesn't apply. I disagree. I say D2 does apply. It was expansion of the existing use. The letter clearly stated back in the original special exception that the request, even though, because you can't segregate off a piece of property, you go by the property boundaries. You can't segregate it off. The request originally back in 1987 was for the rear 2 acres and that he would keep the front 2 acres clear of any storage.
Where's the existing structure? Whenever the principal use of an existing structure
There's a house
is to be
located on the
changed.
property.
Well, that has
Address your comments to me, I'd appreciate
it
it,
is.
because I don't want this to hurt.
There's no evidence with respect to any existing structure, but that's fine. Okay,
There was a house on the property.
If we were, I'm sorry, Mr. Cullen, I didn't know you were still speaking. Go ahead.
There was a house on the property that was originally there that's, whether it was a care back in 1987, whether it was the owner's residence, whether it was a caretaker, whatever it might have been, that was the structure that was spoken of in the special exception.
Okay.
That original house.
I challenge you to go back and look at all of the code violations that have been filed, and there's probably 20 since 2009 that they have had code enforcement filed or code enforcement filed violation after violation after violation after violation, and like I say, it just changes. Never, ever, ever in any of them is there a mention of the word structure or use of a change of the existing structure. This should be denied. This case should be closed. Mr. Neff is happy to refile the application, and if we have to fight with the county, if the county will not issue the CO, and if they say it's got to be current code compliant, then I guess we'll end up in court in a mandamus action or something like that. Mr. Neff's not trying to be obstinate. He's not trying to fight. He's not trying to get anything over on the county. He wants to comply. He's filed the applications. He even had a sign permit and got sign permits on all this stuff. I mean, he's tried to be responsive to everything with the county. The county's the one holding him up.
Any objection to either of these two exhibits?
No objection.
All right, I'm going to mark the September 11, 2013 as the owner's exhibit. I think I'll call that 1. And the email dated May 22nd, 2013, owners 2. And those will be admitted into evidence. And anything further from the parties?
If I just may address his last statement about not requiring it, we've had agreements with every other attorney that has come before us, and every time we come to agreement with them, Mr. Neff changes attorneys, and we find out about it at the very last minute prior to going to the Code Enforcement Board or the Special Magistrate in this case. This has been ongoing. We've had these discussions many times. Even with our discussion last Thursday, Mr. Neff and we came to agreement on to what would be done for landscaping. We've been in discussion with that. So again, Mr. Witt, I don't know what to tell you. It seems like we've been at the same spot. You say the arguments have been fluid. The problem is that the violations have changed. The sign violation was one of them. That has been rectified with the pulling of the temporary advertising sign. But the other violations with respect to yards and commercial name changes, things like that, that's been pretty static the entire time.
Well, I just have to clarify, there has only been Attorney Tiseo and myself. And I think you can understand when your attorney doesn't show up and there's an order entered against you, that may prompt you to do something a little different as far as your representation.
Don't disagree with you. Again, we don't know that he's represented, and so we can't be,
That was, okay.
Look, we'll be here all day if we keep sniping at each other, and I think I've heard enough where I can make my decision. Counsel, I have no doubt that this has been frustrating for you and Mr. Neff, as apparently with the county as well. My biggest concern, however, is the order that was previously entered. And granted, it was entered because Mr. Tiseo failed to appear, but it was entered nonetheless. There was notice and opportunity to be heard. And what concerns me is there was no appeal. And I heard no evidence today that anybody has taken the position from a legal standpoint that the order was obtained illegally or contained an illegal application or whatever to date. And so I'm kind of stuck with the order. And although I'm sure that the county will be willing to sit down with you guys, and probably after my ruling that I'm going to render in just a few minutes, they'll be very inclined to do so. But I really think this thing can be resolved. But as I see the evidence in the applicable law, I'm kind of stuck with that order. And as I said, you've been a zealous advocate on behalf of Mr. Neff's company. I'll give you that. And you seem, very knowledgeable on the point. But I'm sure you can understand that I can't go back and change the order. And that's really what we're here about. The county is asking for the fines. I think you're aware of those. Unfortunately, for Mr. Neff and his company, I'm going to have to rule in favor of the county for the reasons that I've stated. But hopefully the county will sit down and with you and Mr. Neff and get this thing resolved in the near future, because essentially the code enforcement's not interested in fining him, but giving him incentive to get this thing worked out. And hopefully that'll be a two-way street, but that's my ruling.
Okay. Thank you, sir.
Thank you. Okay, let's see. Excuse me 1 minute, I just want to pull up. Oh, I don't know. I can't see that. Have trouble reading the computer screen. Okay, moving on to the next case, we're going to go to agenda item 8, case number 14, COD 1203. 073, Stellar Diving Services, LLC, property located at 23058 Harborview Road, Unit E, Port Charlotte, Florida. Anybody here is here on that case, so they'd approach.
Mr. Siegel. My name is Rod Carnes, and I'm the sole owner of Stellar Diving Services.
All righty, sir. If you just you can wait up there and just stand by, because I'll ask the county to present its issues first, and then we'll move on, and you can present your evidence. Is the county ready to proceed?
Yes. Code Compliance Officer Charlie Bush, certified for Charlotte County, Florida.
Would you excuse me 1 minute? Sir, were you sworn in? I don't know if you were in the...
I did raise my hand.
Oh, okay, thank you. I'm sorry. Go ahead, please.
I'm sorry. Anyhow, this was a late December case, 2012, I'm sorry. Outdoor storage of 2 wing buildings on his structure. Since then, he has taken the wing structures down, which left all the diving gear, outside storage of windows, everything outside. I worked with him as long as I could, and then this was in May. I took 3 pictures of outdoor storage, and he'll admit that it was there. And since then, we're going to file a 1-day affidavit for May 9th.
Anything further from county?
Nothing further.
Sir,
Yes, sir.
you want to tell me what you disagree with the code enforcement officer's testimony?
Quite a few things, but to start with, there's an assumption on his on what he's claiming that I wasn't doing anything to clear up the trash, as the citation calls my very valuable equipment materials. It was scattered by the first citation to take down my structural buildings, which the planning department told me would be okay because they were temporary, but I took them down, exposed all of my materials. I've suffered quite a few losses, and I proceeded to engage the planning permitting process to try and get a compliant addition to my property. And that process has not stopped. From the very first from the time I took the structures down, I had a lot of materials that had been inventoried. Those structures were already in the computer as warehouses. Taking them down just has really cost me a tremendous amount of money. Getting a permit to put the building that I need back up, a 900 square foot roof over structure to keep the rain and the weather off of valuable equipment, has been ongoing since the very moment I took those structures down. And I have the documentation to substantiate that.
Sir, what documentation do you have?
Well, I have the final plan. Let me go through the dates. And on July 10th of 13, I had a notice of violation and a 10-day warning to remove my storage structures. August of 8th of 2013, we had a hearing, and I was granted 90 days to complete the permit process. I began accepting, the concrete's the first thing to do, so I began accepting concrete work from a licensed contractor. And I'm a contractor, but not a licensed contractor, and my intention was to build, it's basically just like the building I had before, only this one would be permitted. But the concrete work, I don't do concrete work. So I paid a licensed contractor to do the concrete work. That was completed October 25th of 2013. And I engaged the planning process. And once the concrete was up, I needed 30 days for the concrete to harden so I could move things with my forklift at least onto the concrete pad. So it would be more protected. I could protect it better, and it would be less like a junkyard. December 10th of 2013, I put $250 down as a down payment to engage Weiler Engineering for plans for my building.
What was that date, sir?
That is December 10th of 2013. Said I completed the concrete work in October 25th. And I had 30 days to wait for concrete, so I was in Louisiana conducting business because I'm in the deep water diving business, and that's where my markets are. And by the time I got back, I had a couple of weeks to work at getting shelving and everything on the pad to get my scattered stuff under as much protection as I can. I don't own a junkyard. I don't own junk. Many of my things have become junk because of the delays in this process, but that's a different issue. But December 10th, I put a down payment for plans for the structure that I need. Those plans were approved on March 23rd of 2014, and I'm anxious to get work completed, but I'm still expecting, when the concrete's done and I'm able to get my permit, and I'd have to have the plans to do it, that I'll be able to build this structure myself because of owner building. But on April 9th of 2014, I brought in a crane from Keesling Construction, and they've moved my equipment quite a bit. And I don't know if Charlie has pictures available here, but if he doesn't, I do before and after pictures. I have Connex boxes that are also on the property. So the pictures that he's submitting to show my junkyard is the result of me moving these large, expensive dive operations pieces of equipment to a different area on my yard so I could put them close together and start tying them together. There's 3 Connex boxes that make up a saturation dive control system. You have a SatTech van, you have a dive control van, and you have an equipment control van. I own all 3 of them. They're all in my yard, and they were on the parking side temporarily, and I had them in places where I had lots of materials either in them or tied to them securely, and I have pictures of those with me. But to continue, my Connex boxes were moved, and in the process of moving them, I had to take all the ropes off of them. This is April 9th of last year, or this year. And in doing so, I laid down a lot of materials in the yard. And again, I have pictures to show where the Connex was and the resulting chaos. But Charlie is presenting the case as if nothing has happened, and I've spent thousands of dollars for 2 years trying to get up and running, and I can't protect my material and equipment without that structure, and I'm in the business of putting human lives at risk. So before I can do that, I have to prove that I can own and operate a shop. In May of 2014, well, Charlie, where was Charlie? So on April 9th, I moved almost everything in the yard. I've hired multiple forklifts to try and save my equipment from the weather exposure, much of it unsuccessfully. I've lost a lot of money here. But Charlie, and I don't know why, I'd like to know if there was a complaint the second time or if he was just doing a follow-up.
Well, I think that's, we'll hear from the county if
Okay,
a rebuttal.
okay. So he inspected it on May 19th, and that's the first time I've learned. As an aside, he informed me that my Connex boxes are not legal in Charlotte County. So at that point in time, assuming he's correct, because he has no reason not to be straight up about the laws, and he knows them, at that time I recognized that I can't do business here, that I have a shallow water diving company, I have a contracting company, and I have a deep water company, which is where my substantial assets are located, and all of them are in Port Charlotte. I set all of these businesses up here to go to work, and now I can't operate my diving company out of here. So my diving company, Stellar Diving Services, was the facility that owned that building. It no longer does own it. I began the process, well, actually also, I learned that my LLC, even though I completely own it, cannot own or build. So I was stopped in 2 places without anyone. I just didn't know that that is what the consequence would be. I didn't expect this consequence of moving my Connex boxes. I didn't know my Connex boxes aren't legal in Charlotte County. They're worth over $500,000, and they're the heart of my saturation diving system. So I made the determination to basically quit claim the building to myself so I could do the work myself, as well as start looking for a new home for my saturation diving company.
And when did you quit claim the title of the property?
Pardon?
When did you quit claim the title of the property?
I initiated it. My quit claim process was completed on August of 22nd. August 22nd is when I finally, it was about a 2-month process because I have a landlord that's doing the financing. So it was back in June that I initiated the work with my attorney, but in order for all the documents to go through the holder of the mortgage and back and to get recorded, it's August of 22nd that I finally was able to take possession myself. And last Monday I was able to have my application, I've applied twice for a building permit, but once it's Stellar Services, and last Monday I applied for a building permit, owner builder. They accepted it, and it has been reviewed and approved downstairs, and it's with the building department, and I'm expecting to have an approval today or tomorrow to go forward with the construction of the roof building.
How's the title properly, how is it titled now?
Rod J. Cairns.
I'm sorry?
Rod Cairns, my name personally.
Okay, thank you. You indicated you had some photographs. What's the most recent picture you have of the property?
Well, I have before and after from the move. Charlie, did you, say you?
I emailed you the five
Right.
pictures.
So that was from back
that's-
then.
But that's what the affidavit is for May 9th is outdoor storage. 19th.
So there was not,
Those five pictures that I sent
Right,
you
right.
of all the outdoor storage you had on May
but
19th.
since then, since I've removed.
No, that's another affidavit, but right now we're for the May 19th.
Yes, sir. We're only here on the this one particular affidavit of noncompliance today. But what I wanted to find out from you is if you have the most current picture of your property.
Possibly, but no, sir, I don't have it printed out.
Let me ask you this: Are these items that you're storing still on your property today?
The Connex boxes are, the materials, anything that was not on the pad is gone, except for things that are going in the structure when I build it. I've been waiting to have a place to put it. But 80%, because I'm not going to be doing deep water diving here, I've removed quite a bit.
All right. Anything further?
I have a couple of questions. Can I have some clarification?
Sir, today's the day that you present your evidence, and questions should have been addressed to the Code Enforcement Board before today. And as a legal matter, I cannot give you any legal advice. Anything from the county?
Nothing further, Your Honor.
Pardon?
I was just checking with the county to see if they had any further evidence. Sir, it appears that the equipment, at least some portion of it, the box material that you described for us, is still on the property. It appears that the violations and...
I'm sorry, what is still on the property?
I think you'd find it as a box material of some sort, and perhaps my nomenclature isn't correct. But there's equipment and items out on the property. I do find that still is a continuing violation. Therefore, I'm going to approve the affidavit and the requested fine. What I would suggest to you, if you can, is you can work with the Code Enforcement Department to try to get this resolved. I don't know.
I've been at it for a year and a half, and I've spent almost $100,000 in losses and expenses.
I understand.
And I haven't earned a nickel yet.
Well, I understand. Hopefully that'll change for you in the future, sir, but I have to go with the evidence in the case, and so
Okay, and
that's my
the
ruling.
evidence is
That you're still,
a nondescript box? What is the evidence, sir?
my nomenclature may not be correct, but there is...
Well, there isn't any junk on my property, so the nomenclature isn't correct, but what is it exactly that I'm being cited for now?
If I could, the May 19th pictures that I sent you with bamboo windows, doors, everything that was outside, that is the outside storage.
So when I spoke with you last week and asked you if you had visited it, you said yes.
And I did, and it's cleaned up, so you won't get another fine.
Oh,
But this is from the 19th.
That's what I'm looking for.
I know, I'm working with you. Very good.
so,
This is just from the 19th. There won't be another one because you are coming in compliance.
Okay. Sir, if I may, I don't want this to just go into a colloquy between the parties here, but I have looked at the affidavit. I'm looking at the photographs now, and I know this is equipment to you. The county sees it differently, and I've made my ruling that I'm going to enforce the affidavit of noncompliance as stated.
despite the activity to control that chaos and the less than 3-week effort before in the moving process that generated that mess?
Sir, everybody appreciates your efforts at trying to get this resolved, and I would encourage you to continue to do so, especially with with the fine now. But it's been a long time, and there's still, while there's been some progress, there's not been enough. There are violations I found to exist, and that's my ruling.
So I can't successfully get a permit, but I can get fined for not having the property, having my materials under roof in a permitted building that I can't get.
Sir, we're not here about that today. You'll have to address
Okay.
that with the, I've got a very narrow.
I know you have an
look at
agenda,
it,
but where would I address that, sir?
You can check out with the building department, code enforcement people, will be able to help you with that as well.
Okay, thank you. And
sir.
how do I pay and who do I pay?
The code enforcement people will help you with that.
You can go over to the building department, give them your case number, tell them you're here to pay the 110 fine, $110.
Okay, and if I give them the case number, they'll know. Okay.
Thank you, sir.
By the way, bamboo is very expensive.
I did? Okay. What? Okay, so now we're on to new business. Okay. And I think we have page 5, yes, but we're going to do what, L, okay. All right, under new business item L.
Excuse me.
On case number COD 12-00552.
Sorry.
I just wanted to check whether you had approved the balance of the affidavits. Okay, thank you.
Missed that. Sorry about that.
Okay, that's all right.
I have one of those days.
Yeah. Okay. At this time, we'll call the new business agenda item L, case number COD 12-00552, Omni Sports LLC. Counsel, would you announce your appearance, please?
Good morning. My name is Jerry Waxler. I'm an attorney with the McCrory Law Firm here on behalf of ONMI Sports LLC.
Okay, thank you. Nice to meet you, ma'am. County, ready to proceed?
Yes, officer.
My name is Andre Deshane, Certified Code Enforcement Officer, Charlotte County. 2551 Taylor Road, Punta Gorda is zoned commercial intensive. The owner of record is ONMI or ONMI LLC. This case was initiated by Officer Gravagna. Reference commercial building permit had expired and was renewed and ultimately expired again on July 9th, 2013. A courtesy letter was sent out by Officer Gravagna on March 7th, 2012, outlining the violations and allowing 30 days for compliance. Charlotte County and Dr. James White entered into a compliance agreement on October 4th, 2012. Dr. James White also signed an affidavit and attested that the property was not in compliance with building and zoning and regulations and laws, and construction was to be finalized within 15 months or by January 2014. During the investigation, I took photographs of the property on July 11th and August 27th, 2014. These photos fairly and accurately represent the conditions I observed. If the respondent has no objections to the photos, I would like to offer the photographs, copies of the expired permit history, compliance agreement into evidence, composite exhibit number 1.
All right, I'll give counsel a moment to review the proposed exhibit.
Is that the only photo, the one that you have up? And the one that's in here? I have no objection. No.
Okay, composite exhibit number 1 for the county be admitted. There being no objection.
The amended notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. On August 27th, 2014, I conducted the final inspection, finding the garage still present, and a review of the permitting database found an expired permit for the structure.
Does county have anything further?
Just the recommendation.
Okay, we'll come back to that then. Counsel?
Yes. I want to clarify, because I'm holding the amended notice of violation, that what we are here today to discuss is an alleged violation that they have allowed a permit to expire without obtaining final inspections. Is that correct? Is that what the violation is that we are here today to discuss?
Have you seen the affidavit of noncompliance, ma'am? Oh, I'm sorry. Go ahead, my error.
I believe this is also discussing the settlement agreement, or I forget what we had called it, regarding the site work, the compliance agreement regarding the site work and everything, also which has expired without meeting the deadlines that was entered into between Dr. White and the county.
Because the amended notice of violation just states that it resulted in a finding that the permit for a commercial building for sports training and skill development had expired without final inspections being conducted, that it is a violation of certain specified sections. So I want to be very clear, because that's what the notice stated. I want to know what it is today that we are here to discuss and what you're here to rule on.
Ma'am, we're here on the items set forth in the amended notice of violation, particularly as stated, section 105.4, conditions of the permit, and the subsection cited thereunder, section 110.3, required inspections, and the subsections that are cited in the notice of violation.
Okay, very good.
And let me just get to the bottom here. That's it.
Okay. Then, to address specifically those code sections, we are allegedly here because the failure to get final inspections being conducted and after the permit had expired is what creates the violation, according to what they say here. Looking at the specific code provisions that they have identified, very clear that the permit has expired. We concede to that. We admit to that the permit has expired. The fact that the permit has expired and that there were no final inspections obtained before the permit has expired, however, does not result in a violation of the sections that they have provided. If you look specifically at 105.4.1.1, they say if work has commenced and the permit is revoked, becomes null and void, or expires because lack of progress or abandonment, a new permit covering the proposed construction shall be obtained before proceeding with the work. Implicit in that is this idea that there was additional work that has to be completed and you have to get a new permit. It does not state you must get final inspections before a permit expires. Similarly, 105.4.1.2 sets forth specifically what should happen if a permit expires. It says if a new permit is not obtained within 180 days from the date of the initial permit, that becomes null and void, the building official is authorized to require that any work which has been commenced or completed be removed from the building site. That has not occurred, and we would ask that that not occur, and I'll explain why lately. And then alternatively, a new permit may be issued on application. There is nothing in this code section that states that final inspections have to have occurred before a permit is expired. In fact, routinely, it happens all the time here in Charlotte County. You get a permit, work is suspended, the permit expires. You must then come back in and get a new permit, and you must take that permit to completion. Inherent in something expiring is that it hasn't been completed, and if it hasn't been completed, you can't obtain final inspections. So I would argue that the violation that they are alleging is in fact not a violation. There is nothing in this code section that would provide that failing to obtain final inspections is a violation of this section. In fact, the language of the section itself, as I pointed out previously, speaks to the fact that if a permit does expire, you need to get a new permit covering the proposed construction before you begin proceeding with the work again. You cannot have final inspections when there is a situation where you're going to proceed with work again. So that in a nutshell, I don't believe that there is any basis in law for the violation that has been alleged.
If I may jump in real quick, the building official and commercial plans examiner is here for follow-up. This is out of my bailiwick, so if you'd like to question him or like him to testify,
Yeah, let me make sure Ms. Wexler's had a chance to present her full case.
I just wanted to put it out there.
I would like to, at some point, and I think this is the germane issue here, whether or not there's even a basis for for alleging that there is a violation. And I don't believe that there is a basis in law for this violation. I would like to speak a little bit about the situation here. The permit did expire. They have obtained, but I don't want it to make it sound like nothing was done. They submitted, subsequent to the time that the permit expires, submitted plans and resubmitted plans to try and get a new permit to be able to continue. Those plans were rejected. The last set of plans was submitted, I guess it was according to the file history that was submitted, looks like in January of this year was when the final denial of the plans was received. They have, in addition to that, went through during the same process, got final site plan approval, obtained a permit from the Southwest Florida Water Management District, and actually began digging the water management facility on the site. When they began digging it, they found tires and all kinds of other things under the ground. That has hampered this process because the discovery of that meant that he could not get the financing that he needed to then move forward with some of these repairs. Additionally, we had a meeting in March of 2014, on March 17th, where we explored the idea that the business that these changes are required for is no longer operating. And we talked about coming in, this is a very unusual piece in that it has land use that is parks and recreation, but zoning that is commercial intensive, because the use that they wanted to move forward with was a sports training facility. That use has now ceased and is not moving forward. So my client, I have been retained, and I have a retainer letter, I have an actual dollar retainer, and I have also received from the client the check made payable to the Charlotte County Board of County Commissioners so that I can submit an application to change the land use to commercial. When the land use is commercial and the property is CI, this building will then be a different type of commercial use that will require different types of improvements. So to move forward with the improvements that were required for the sports training facility when that business is no longer going to be in effect makes no sense. I will be submitting that land use change application this month. It will get through the process and be done. If I submit it this month, I guess will be done by January. And then they would be able to move forward to get a building permit for whatever improvements are required for the new use. I just provide that as background because I do believe that the germane issue here is whether or not there is in fact any basis for a code violation when there is nothing in the code that requires that you have final inspections before a permit expires, and in fact the language is completely contrary to that.
Thank you. Just give me a minute, please. Ms. Webster, do you have anything further?
Not at this time, no.
Okay. Rebuttal?
We just have our recommendation.
All right. What concerns me in this matter is I'm skimming the provisions of the Building Code Section 105.4 as well as the 110.3 regarding the required inspections. I believe that, you've admitted that their permit is expired, apparently for some time, and I guess from a development side, your client's trying to figure out what it needs to do to get this thing resolved. However, I do find that the building inspections should have been made and were not made, and therefore that there is a violation as set forth in the section cited in the amended notice of violation. And I'm directing this to the county for a recommendation.
The county requests that respondent be found in violation of sections 105.4 and 110.3 of the Florida Building Code and be given 30 days from the date of this order to renew the expired permits or otherwise come into compliance with the county's building and zoning regulations, or thereafter face a fine of $100 per day for each day the violation is shown to exist.
May I address?
Yes, ma'am.
There was an inspection that was done that found that work had been completed that was not up to the codes for the use that was proposed. They have to then submit plans and get those plans approved before they can do the work and then have that work inspected. they submitted on multiple occasions plans. Those plans have never been approved, so there was never the new work done that could have been subject to an inspection.
Why were the plans not approved?
It's in there, it's a whole variety.
Right. They were unapprovable. I think it had to do with the assembly, things like that, with the requirements of assembly. Under Florida Building Code, if it's a place of assembly, there are certain, and again, I'm just, I've been more on the zoning side of it, working with the applicant. So I'm just going by.
They range from things that, and if you look at the permit history, from things that a signature wasn't in the right place to the plans that the architect did up only showed what was existing, not what was opposed. They were done, they were corrected, they were submitted again, they were rejected again, they were corrected, they were submitted again, they were rejected again, and there have not been new plans submitted since December of last year. That, again, that's reflected in the history. But without approved plans, the work was not proceeding. Without the work proceeding, there were no inspections to be had.
And what was the basis for the last rejection of the resubmitted plans?
I don't know. You can address that to the building official if you'd like him to come up.
Yeah, that's okay. That'll be up to the county to do. Do you want to call any other witnesses at this time?
We have no further witnesses.
Okay, that's fine.
I have and if I don't know who I would give this to look at. I had printed out the review status, and you can see the various notes and things on that so that you can see what was done and why they were rejected. Is there someone who wants to look at this before I submit this into the record? Just to see.
Any objection to me reviewing this?
No objection.
Yep.
And I would note again that the violation is not that we did not receive inspections. It's that the permit expired and we had not received final inspections. And there is no requirement. In fact, it's implied that you may abandon work before the building is complete and that you can apply for a new permit to complete the construction. You would not be able to get a final inspection prior to having completed the building.
You just put that. I'll have them bring it up to you. All right. My ruling is as follows. I'm going to find that there is a violation of the sections cited in the amended notice of violation, and I'm going to modify the county's recommendation and provide you 60 days from the date of my order to renew the expired permits and pass the inspections. in accordance with the Florida Building Code or obtained a demolition permit to remove all improvements on the property, will impose a $75 a day fine.
After that time or from
I'm sorry?
after the 60 days?
Yeah, it'll be suspended until after the 60 days for compliance.
Thank you.
Could you give her this? Okay. He actually had a copy of it, but it was just not sold right now. That's the, okay, then that's the last of the people present. One more, which would be, okay, that is number, Cora Carrier. Page 7, okay. Oh, there it is, okay. All right, at this time, we'll call the agenda under new business, item M, case number COD 12-00706, property owner Cora Carrier, 5600 Blackjack Court, Punta Gorda, Florida. Is anyone here present on that? And if so, would step up to the podium. I understand she was here earlier.
Yes, I believe the owner at the address 5600 Blackjack Court was present.
She's not here. I don't see him.
Okay, you're going to check the hallway?
Yes.
Okay.
Actually, it appears that no one is present for the respondent.
I'm sorry, she's not in the hallway?
Correct.
Okay. All right, then we'll go ahead and proceed since I have the case called.
Andre Deshane, Certified Code Enforcement Officer for Charlotte County. 5600 Blackjack Court, Punta Gorda is zoned RE5 residential estates. The owner of record is Cora Carrier. This case was initiated by Officer Gravagna, reference to windows installed without permit. Owner applied and permit was rejected. On February 25th, 2014, I conducted an inspection and review of permitting database, and observed permit was still in rejection. I also reviewed the property appraiser photo database and found that an interior remodel had been done without permits. During the investigation, I took photographs of the property on March 31st, 2014 and August 27th, 2014. And property appraiser employee Dina Hall took photos on December 20th, 2011 and December 28th, 2012. My photos fairly and accurately represent the conditions I observed. Dina Hall can testify reference her photos, and I'd like to introduce her now, and then I'll go on afterwards.
Those photographs have been submitted. I'll mark them as County Exhibit Composite Number 1. There being no objection, they'll be admitted into evidence.
Thank you.
I'm Dina Hall. Dina Hall,
Yes, ma'am.
staff appraiser with the Charlotte County Appraiser's Office.
Okay.
I took those photos on the dates that are mentioned are documented on the photos, showing the state of demolition or progress of construction.
Okay. These photos were taken December
20th,
11.
2011, yes.
All right. Okay. Anything further?
No. There was another set of photo taken 12/28/2012 showing the finished home. Did you want to go back to that? There, that's the December 28th, 2012.
Okay. What's the date on that?
December 28th, 2012.
It's on screen. In essence, it's showing the finished product.
Oh, I see that. Okay, I was just looking at my packet here.
I'm sorry.
That's what I'm saying. I'm looking for the, okay.
Yeah, I'm not sure where it is in the packet.
I'll make sure it all gets into evidence. 1220. Okay, I've got it. Okay. As I said earlier, the composite exhibit 1 containing these photographs has been authenticated, admitted.
And since we've already entered these in as County Composite Exhibit 1, I guess we'll go, code compliance request was left by me on February 25th, 2014, outlining the violations and allowing 30 days for compliance. The notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. On August 27, 2014, I conducted a final review of the permitting database, finding no permits applied for interior remodel and windows permits still in rejection. On a side note, a new permit was just applied for, I'm not sure, Thursday or Friday. It's in review to replace the windows, one door, and knock down and build a wall, which obviously from the pictures was more was done than just that.
Okay. Any further testimony, sir?
No, sir.
Can you have anything further?
The county requests that respondent be found in violation of sections 3-9-5 sub B and 3-9-31 sub D of the Charlotte County Code and section 105.1 of the Florida Building Code, and that they be given 30 days from the date of this order to apply for and obtain all necessary permits in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day the violation is shown to exist.
Okay. Again, the record note that the property owner was here earlier, that we sounded the hall. She was not here. Case number COD 12-00706, Charlotte County versus Cora Carrier. I find that the violations set forth in the notice violation do exist, that there is a violation, therefore find the property owner guilty. I'll accept the county's recommendation, hereby order that the owner will have 30 days from the date of my order to apply and obtain all necessary permits in accordance with the Florida Building Code and assess a $50 a day fine until there's been compliance. Oh, I'm going to find your name. Yep, that goes in there too. Okay, now I got to figure out where we are. Okay, now back to A. Okay. Alrighty, at this time, we'll go back to Article 9 of the agenda, new business, Case A, COD 1400362, property owner Home Opportunity LLC, 21947 Salini Avenue, Port Charlotte, Florida. County ready to proceed?
Yes, officer.
Yes.
Okay.
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 21947 Salini Avenue is zoned RSF 3.5, and the owner of record is Home Opportunity LLC. On February 14th, in response to a complaint, I conducted an inspection of the address and observed the following violations: high grass, unprotected damaged exterior door frames, damaged exterior walls, and a review of permitting found an expired roof permit that expired November 18th, 2008. During the investigation, I took photographs of the property on February 14th, April 8th, June 26th, and August 26th. These photos do fairly and accurately represent the conditions I observed. On April 8th and June 26th, I conducted a review of the permitting database and found the permit remains expired. I would like to offer the photographs and a copy of the permit history into evidence as County Composite Exhibit 1.
Okay. I've received the exhibits, the photographs, and the computer-generated page. I've marked them, and we'll accept them into evidence as the County Composite Exhibit number 1.
A warning letter was sent outlining the violations and allowing for 30 days for compliance. I conducted re-inspections on April 8th and June 26th and observed that the grass was cut, but there was no change in other conditions. I received a voice message on September 2nd from Asia Cash of Halo Asset Management, returned the call and left her a message. Notice of violation, notice of hearing was served in accordance with Chapter 1, with Florida Statute 162. The respondent was given 10 days to come into compliance with the listed violations. On August 26th, I conducted the final inspection and reviewed permitting, finding no change in conditions.
Anything further, ma'am?
No, sir.
Anything further from the county, other than the recommendation?
No, sir.
Okay, well, what is the county's recommendation, please?
The county requests that respondent be found in violation of sections 3-2-115 of the Charlotte County Code, sections 105.4 and 110.3 of the Florida Building Code, and sections 301.2, 301.3, 304.2, 304.6, and 304.13 of the International Property Maintenance Code, and be given 30 days from the date of this order to register the vacant property and renew the expired permits and pass inspections in accordance with the Florida Building Code and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day the violation is shown to exist.
All right, case number 1400362, Charlotte County versus Home Opportunity LLC. Based on the unrefuted evidence, I find that the notice of violation charges under 3-2115 and FBC sections 105.4 and 110.3 and IPMC sections 301.2, 301.3, 304.2, 304.6, and 304.13 have been established, and find that the property owner is guilty of in violation of those sections. I adopt the county's recommended order that the property owner will have 30 days from the date of my order to register the vacant property, to renew the expired permits, and pass all inspections in accordance with the Florida Building Code, and to bring the property into compliance with the International Property Maintenance Code. I will order $100 a day fine until such time as the property owner is found to be in compliance. This time we'll call under new business Article 9, case B, COD 14-00884, Tenny and Anastasia Frigadakis, I hope I'm pronouncing that correctly. County ready to proceed?
Yes, sir. My name is Rhonda Leonard, and I'm a certified code enforcement officer for Charlotte County. 21431 Midway Boulevard is zoned RSF 3.5, and the owners of record are Anastasia Fragidakis and Tenny Fragidakis. On April 15th, I responded to a complaint and conducted an inspection of the address and observed the following violations: of high grass and weeds, outside storage of broken toys, boxes, an ottoman, trash, and assorted other items, and a fence in disrepair. During the investigation, I took photographs of the property on April 15th, May 13th, June 24th, and August 26th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
All right, there being no objection, as the owner is selected not to appear today, composite exhibit number 1 has been so marked and accepted into evidence. Please proceed.
Warning letter was sent outlining the violations and allowing 20 days for compliance. I conducted re-inspections on May 13th and June 24th and observed no change in conditions. I spoke with Anastasia Fragidakis on July 2nd. Our conversation was ended quickly as the respondent was very hostile and belligerent. Notice of violation, notice of hearing was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance with the listed violations. On August 26th, I conducted the final inspection, finding no change in conditions.
Any further evidence at this time?
No, sir.
County recommendation, please.
County requests that respondent be found in violation of sections 2-5-72, 3-9-32 sub D, and 3-9-82.1 of the Charlotte County Code, and sections 301.2, 302.1, and 302.7 of the International Property Maintenance Code. Be given 15 days from the date of this order to clear the zoning violations, and 30 days from the date of this order to apply for and obtain all necessary permits in accordance with the Florida Building Code, and bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day the violation is shown to exist, and for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
Okay. Case Charlotte County, Tenny and Anastasia Fragidakis. I truly hope I'm pronouncing that name correctly. Case 14-00884. I find that the unrefuted evidence establishes the notice of violation charges, specifically sections 2-5-72, 3-9-32, subparagraph D, 3-9-82.1, IMP sections 301.2, 302.1, 302.7. Those violations existing on parcel ID 4022-152-76002, accept the recommendations of the Code Enforcement Board. Hereby order that the property owners shall have 15 days from the date of my order to clear the zoning violations, 30 days from the date of my order to apply for and obtain all necessary permits in accordance with the Florida Building Code, and to bring the property into compliance with the International Property Maintenance Code. I will assess $50 a day fine till compliance, a 2-year cease and desist order for the zoning violations, and grant the requested abatement procedures requested by the county.
Thank you.
And she took off with my order. Okay, thanks. Let's see, 14023. All right, next case will be agenda item 9, case D on the agenda, COD case 14-01023, Yunker, Charlotte County LLC, property address 3460 Westland Terrace, Port Charlotte, Florida. Anybody present on that case step forward. I note that the owner is not here, so if the county's ready to proceed.
Officer Leonard?
My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 3460 Westland Terrace is owned RSF 3.5. The owner of record is Yonkers Charlotte County, LLC. On April 28th, I conducted a proactive inspection of the address and observed following violations of outside storage of trash, boxes, clothing, and assorted other items. During the investigation, I took photographs of the property on May 14th, June 12th, June 30th, August 4th, and August 26th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
All right, I've received the composite exhibit. There being no objection, as no one's present on behalf of the owner, they'll be accepted as County Composite Exhibit 1.
A warning letter was sent outlining the violations and allowing 10 days for compliance. I conducted re-inspections on May 14th, June 12th, and June 30th. Observed that the junk conditions had been corrected, but noted screens missing from windows, windows open, leaving the residence unsecured, damaged fascia, damaged exterior walls, and windows boarded with what appeared to be whitewashed cardboard. I spoke to the property manager on June 12th and advised of my findings and received a message from the owner, but have not spoken to her. An inspection on August 8th found there was also high grass and weeds. An amended notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance with the listed violations. On August 26th, I conducted the final inspection, finding the grass had been cut, but all other conditions remained unchanged.
Anything further from the county other than the recommendation?
No, sir.
And the recommendation is?
County requests the respondent be found in violation of sections 2-5-72 of the Charlotte County Code, sections 108.1.5 sub 7, 301.2, 301.3, 304.2, 304.6, 304.7, 304.13, 304.13.1, 304.14, and 305.1 of the International Property Maintenance Code. And that they be given 15 days from the date of this order to clear the zoning violations and 30 days from the date of this order to bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day the violation is shown to exist, for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
I was going to ask you if you could repeat that. All right. Case number COD 14-01023, Charlotte County versus Yonkers, Charlotte County LLC. I find that the property owner has been properly served and has failed to appear or present any evidence. I find that the unrefuted evidence establishes the violations set forth in the charge, the notice of violation, except for 3-9-32D and 3-9-82.1, which have been dismissed. Except the county's recommendation, the property owner shall have 15 days from the date of this order to clear the zoning violations and 30 days from the date of this order to bring the property into compliance with the International Property Maintenance Code. I'm assessing a $100 a day fine and issuing a 2-year cease and desist order for the zoning violations and awarding the requested abatement should it become necessary. Okay, so give you that one. Okay. Then we'll get that mixed up. Alrighty, we'll go to under new business, Article 9, Case E on the agenda, Case COD 14-01130, Jeff Gottfried, property address 21219 Meehan Avenue, Port Charlotte, Florida. I note that the property owner is not present, so if the county is ready to proceed.
Yes. My name is Rhonda Leonard. I'm a certified code enforcement officer for Charlotte County. 21219 Meehan Avenue is owned RSF 3.5. The owner of record is Jeff Gottfried. On May 9th, I conducted a proactive inspection of the address and observed the following violations of outside storage of furniture, buckets, bins full of debris, and assorted other items. During the investigation, I took photographs of the property on May 27th, June 26th, August 15th, and August 26th. These photos fairly and accurately represent the conditions I observed. I'd like to offer the photographs into evidence as County Composite Exhibit 1.
The owner not having appeared, there being no objection, the photographs have been marked as County Composite 1, are hereby accepted into evidence. Please proceed.
Warning letter was sent outlining the violations and allowing 10 days for compliance. I conducted re-inspections on May 27th and June 26th and observed the outside storage remains, and there is also high grass and weeds. I received a message from the owner but have not spoken to him. Notice of violation was served in accordance with Florida Statute 162 by posting on August 15th. Respondent was given 10 days to come into compliance with the listed violations. On August 26th, I conducted the final inspection, finding the grass had been cut, the outside storage removed from the front yard, but is now located in the rear.
Anything further from the county other than the recommendation? And if not, just what is the recommendation?
Sure. The county requests that respondent be found in violation of sections 2-5-72, 3-9-32 sub D, and 3-9-82.1 of the Charlotte County Code, and be given 15 days from the date of this order to clear the zoning violations, or thereafter face a fine of $50 per day for each day the violation is shown to exist, for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
All right, case number 14-01130, Charlotte County versus Jeff Gottfried. I find that the unrefuted evidence establishes the violations of the cited sections 2-5-72, 3-9-32D, and 3-982.1. The property owner is guilty of those charges. I hereby order that the property owner shall have 15 days from the date of this order to clear the zoning violations. I'm assessing a daily fine of $50, entering a 2-year cease and desist order for the zoning violations, and awarding the requested abatement should it become necessary. Agenda item under new business, Article 9, Case G, case number COD 14-00858, Kathleen Hart Warren, property address 6210 Granger Street, Englewood, Florida. I note that the property owner is not present today. Is the county ready to proceed?
Yes.
Yes.
Officer?
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is located at 6210 Granger Street and is zoned RSF 3.5. The owner of record is Kathleen Hart Warren. On April 10th, I conducted an inspection of the address and observed the following violation: outside storage of containers, boxes, furniture, steamer, trash, and assorted other debris. During the investigation, I took photographs of the property on April 23rd, May 12th, June 26th, and August 28th. These photos fairly and accurately represent the condition I observed. I would like to offer the photographs into evidence as County Composite Exhibit 1.
There being no one here to object, the foundation properly laid, the Composite Exhibit 1 for the county is hereby admitted into evidence.
The notice of violation, notice of hearing, was served in accordance with Chapter 162. The respondent was given 10 days to come into compliance regarding the existing violations. On August 28th, I conducted a final inspection, finding the violations were removed from the property. I'm requesting a 2-year cease and desist on this property, as another case had been dismissed for the same violations.
Anything further from the county?
The county requests that respondent be found in violation of sections 3-9-32 sub D and 3-9-82.1 of the Charlotte County Code, and that they be given 15 days from the date of this order to clear the zoning violations, or thereafter face a fine of $50 per day for each day the violation is shown to exist, for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
All right, for the record, Charlotte County versus Kathleen Hart Warren, case COD 14-00858. I find that the unopposed evidence establishes the code violations, section 3-9-32D and 3-982.1, therefore find the owner guilty of those violations. I adopt the county recommendation. The property owner has 15 days from the date of this order to clear the zoning violations. I'm assessing a $50 a day fine with requested 2-year cease and desist order for the zoning violations, and the awarding the abatement in the event it's needed.
Thank you.
Okay, get down. Get that. Okay. Agenda item Article 9, Case H, COD 14-01084, property owner Carolyn Herman, 6300 Bunting Lane, Inglewood, Florida. I note that the owner is not present. If the county is ready to proceed, call your first witness.
Officer Nicolosi.
Darcy Nicolosi, Certified Code Enforcement Officer for Charlotte County. The property in violation is located at 6300 Bunting Lane and is zoned MHS. The owner of record is Carolyn S. Herman. On May 6th, I conducted an inspection of the address and observed the following violation: outside storage of lawnmowers, fencing, planting pots, carport full of debris, and assorted other debris. Also observed high grass and weeds. During the investigation, I took photographs of the property on May 6th, June 26th, and August 28th. These photos fairly and accurately represent the conditions I observed. I would like to offer the photographs into evidence as County Exhibit 1.
All right, there being no objection, Composite Exhibit 1 is hereby so marked and admitted into evidence. May we proceed?
The notice of violation, notice of hearing, was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance regarding the existing violations. On August 28th, I conducted the final inspection, finding majority of outside storage removed from the property and the grass had been cut.
Anything further from the county, other than the recommendation? If so,
The county requests that a respondent be found in violation of sections 2-5-72, 3-9-36 sub D, and 3-9-82.1 of the Charlotte County Code, and be given 15 days from the date of this order to clear the zoning violations, or thereafter face a fine of $50 per day for each day the violation is shown to exist, for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
thank you. Case Charlotte County versus Carolyn S. Herman, case number COD 14-01084. I find that the unrefuted evidence establishes the violation of ordinances 2-5-72, 3-9-36D, and 3-9-82.1. Those existing on parcel ID 4120044. 03006. I adopt the county's recommendation, hereby order that the owner has 15 days from the date of my order to clear the zoning violations. Additionally, we'll be assessing a $50 a day fine until there's been a correction of the violations, issue a 2-year cease and desist order for the zoning violations, and granting the abatement request should it be necessary. Thanks. Does that mean I get it there? All right. Let's see, Riles. Agenda item 9, case I, COD case 14-00100, Robert Riles, Jr., the owner. property located 25349 Ison Drive, Punta Gorda. I note that no one is here on behalf of the owners. The county ready to proceed?
Yes, Officer Dalton.
Rick Dalton, Certified Code Enforcement Officer for Charlotte County. The property in violation is located at 25349 Ison Drive and is zoned RSF 3.5. The owner of the property, owner of record, is Robert E. Riles. On January 14, 2014, based upon a complaint of the above address, I observed the following violations: junk-like conditions, above-ground swimming pool not being maintained in a clean and sanitary manner, and the screen panels torn and missing, leaving the pool unsecured. During the investigation, I took photographs of the property on January 14, 2014, April 4th, 2014, June 2nd, 2014, and August 22, 2014. These photos fairly and accurately represent the conditions I observed. I would like to offer the photos into evidence as County Composite Exhibit 1.
There being no objection, I've marked the composite exhibit as County Exhibit Number 1. They're hereby admitted into evidence.
The notice of violation was served, posted in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference the existing violations. On August 22, 2014, I conducted the final inspection, finding no change in conditions.
Anything further from the county other than the recommendation? If so, what is the recommendation?
County requests the respondent be found in violation of sections 3-2-115, 3-9-32 sub D, and 3-9-82.1 of the Charlotte County Code, section 424.2.17 of the Florida Building Code, and sections 301.3, 303.1, and 303.2 of the International Property Maintenance Code. Be given 30 days from the date of this order to clear the zoning violations, to secure the pool in accordance with the Florida Building Code, and to bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day the violation is shown to exist, and for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
Okay. All right. Charlotte case, County versus Robert E. Riles Jr., case 14-00100, pertaining to parcel 402-305214-004. I find that the unrefuted evidence has established the violations of the Code 3-2115, 3-9-32D, and 3-982.1, FBC Section 424.17, and IPMC Sections 301.3.1 and 303.2. I accept the recommendation of the county and hereby order the owner to, I'll give them 30 days from the date of this order to clear the zoning violations and secure the pool in accordance with FBC 424.2.17, and to bring the property into compliance with the International Property Maintenance Code. I hereby assess $50 a day fine and issuing a 2-year cease and desist order for the zoning violations, and grant the abatement request should it become necessary. So, oops, let me put that back in there. Okay, we're up to Plummer. New business agenda item 9, case G, COD 11-00168, Jude and Kimberly Plummer, property address 18587 Robinson Avenue, Port Charlotte, Florida. I note that the property owners are not present today. Is the county ready to proceed?
Yes, Officer Reinwald.
Lyndon Reinwald, Certified Code Compliance Officer for Charlotte County, Florida. 18587 Robinson Avenue is zoned RSF 3.5, and the owners of record are Jude and Kimberly Plummer. June 23, 2014, review of the permit database resulted in finding permit 2006-082-048 for interior remodel and new roof on a residence had expired again on June 3rd, 2014. The permit had been previously renewed 2 times after receiving reminder letters of its impending expiration. During the course of the investigation, I took a photograph of the property on June 23rd, 2014. This photo fairly and accurately represents the conditions I observed. On July 25th of 2014, a review of the permitting database found that the subject permit remained expired. I would like to offer the photograph and a copy of the complete permit history printout into evidence as County Composite Exhibit Number 1.
All right, there being no objection, I've marked the composite exhibit as County Composite Exhibit 1, and it's hereby admitted into evidence. You may proceed.
August 11th of 2014, a notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, reference existing violations. September 2nd of 2014, I conducted the final pre-hearing inspection, finding that the permit remains expired.
Anything further from the county, other than the recommendation?
County requests the respondent be found in violation of sections 105.4 and 109.3 of the Florida Building Code and be given 30 days from the date of this order to renew the expired permits and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day the violation is shown to exist.
All right, county case, Charlotte County Jude versus Jude Plummer and Kimberly Plummer, case COD 11-00168. Find that the unrefuted evidence establishes the violation of the Florida Building Code sections 105.4 and 109.3, and therefore adjudicate the property owner guilty of of those violations. I accept the recommendation from the county. The property owners have 30 days from the date of my order to renew the unexpired permits and pass all inspections in accordance with the Florida Building Code, and I'm going to assess a $50 a day fine until there's been proper compliance and the violations have been cleared. We're going to agenda item 9, new business case O, case number COD 12-00311, property owner Mike Hester, located at 22457 Olean Boulevard, Port Charlotte, Florida. I note for the record that the owners have not appeared today. Is the county ready to proceed?
Yes, Officer Bush.
My name is Charlie Bush. I'm certified code enforcement officer for Charlotte County. The address is 22457 Orleans Boulevard and is zoned RSF 3.5, and the owner of record is Mike Hester. On August 1st, 2014, based on an investigation, I conducted an inspection of the address and observed the following violations: an expired fence permit. During the investigation, I took photographs of the property on February 3rd, 2012. These photos fairly and accurately represent the conditions I observed. Also on August 1st, 2014, I conducted a review of the permitting database and found the fence permit expired. I would like to offer the photograph and copies of the expired permit history as an evidence for the County Composite Exhibit Number 1.
Do you have those? Thank you, sir. All right, there being no objection, I've marked the composite exhibit as Charlotte County Exhibit Number 1, which includes the computer readout and the photographs, and they're hereby admitted into evidence. If you'd proceed, please.
I conducted reinspection on August 1st, 2014, observed that the fence permit had expired. Notice violation was posted according to Florida Statute 162, and the respondent was given 10 days to come into compliance, referring for the existing violation. On August 28, 2014, conducted the final inspection and review of the permitting database, finding the fence permit remains expired.
Anything further from the county other than the recommendation?
County requests that respondent be found in violation of sections 105.4 and 109.3 of the Florida Building Code and be given 30 days from the date of this order to renew the expired permits and pass all inspections in accordance with the Florida Building Code, or thereafter face a fine of $50 per day for each day the violation is shown to exist.
All right, Charlotte County versus Mike Hester, case COD 12-00311, relating to parcel ID 4022232290007. I find that the unrefuted evidence establishes violations of section 105.4 and 109.3 of the Florida Building Code. I therefore adjudicate that the owners are in violation. I adopt the recommendation by the county and hereby order the property owner to 30 days from the date of this order to renew the expired permits and pass all inspections in accordance with the Florida Building Code, and I'll assess the $50 a day fine until there's been compliance. On the agenda, Article 9, new business, Case P, COD 13-00547, Daniel Alston, property located at 3573 Port Charlotte Boulevard, Port Charlotte, Florida. I note for the record the owners are not present. Is the county ready to proceed?
Yes, Officer Bush.
My name is Charlie Bush, Certified Code Enforcement Officer for Charlotte County. 3573 Port Charlotte Boulevard is zoned RSF 3.5, and the owner of record is Daniel Alston. On March 15, 2014, based on an investigation, I conducted an inspection of the address and observed the following violations of work without a permit. During the investigation, I took pictures of the property on May 21, 2014. These photos fairly and accurately represent the conditions I observed. Also on August 4, 2014, I conducted a review of the permitting database and found the permit in rejection. I'd like to offer these photographs, copies of the permit history, into evidence as County Composite Exhibit 1.
There being no objection, I've marked Charlotte County Composite Exhibit 1 is hereby admitted into evidence. You may proceed.
I conducted the reinspection on March 28, 2014, and observed that the permit remains in rejection. Notice of violation was served in accordance with Florida Statute 162. The respondent was given 10 days to come into compliance, referring to the existing violation. On August 28, 2014, I conducted the final inspection, reviewed the permitting database, finding the permit remains in rejection.
Anything further from the county?
County requests the respondent be found in violation of section 105.1 of the Florida Building Code, be given 30 days from the date of this order to apply for and obtain all necessary permits in accordance with the Florida Building Code. Thereafter face a fine of $50 per day for each day the violation is shown to exist.
All right, Charlotte County versus Daniel Alston, case COD 13-00547, parcel ID 4022284850013. I find that the evidence establishes the violation of section 105.1 Florida Building Code. I hereby adjudicate the property owner guilty. I adopt the county's recommendation and direct that the owner apply and obtain all necessary permits in accordance with the building code 30 days from the date of my order, and hereby assess a $50 per day fine until the property is brought into compliance. You want me to fill those out, or? All right, Article 9, new business on the agenda, Case Q, COD 14-0075, David Chalupka, property address 114 Revere Street, Port Charlotte, Florida. County ready to proceed?
Yes, Officer Bush.
My name is Charlie Bush. I'm a certified code enforcement officer for Charlotte County. 114 Revere Street is zoned RSF 3.5, and the owner of record is David Chalupka. On April 3rd, 2014, based on an investigation, I conducted an inspection of the address and observed the following violation of work without a permit and high grass. During the investigation, I took photographs on the property on April 3rd, and these photos fairly and accurately represent the conditions I observed. Also, on April 3rd, 2014, I conducted a review of the permitting database and found no remodel permit. I would like to offer these photographs and into evidence in County Composite Exhibit 1.
Thank you. I'm going to quit doing that. All right, I've received what's been offered as County Composite Exhibit 1, so marked. There being no objection, they're admitted into evidence. May I proceed?
A notice of violation was posted in accordance to Chapter 162. The respondent was given 10 days to come into compliance, referring to the existing violations. And on August 28, 2014, I conducted a final inspection and reviewed the Charlotte County database, finding no permit on file, and the grass remains long.
County, have anything further?
County requests that respondent be found in violation of Sections 2-5-72 and 3-9-5 sub B of the Charlotte County Code, Section 105.1 of the Florida Building Code, and Section 304.13.1 of the International Property Maintenance Code, and be given 30 days from the date of this order to clear the zoning violations and apply for and obtain all necessary permits, to bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $100 per day for each day the violation is shown to exist, and for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
All right, Charlotte County versus David Chalupka, case 14, COD 14-00785. Regarding parcel 402222179030. I find that the unrefuted evidence establishes that the existence of violations of sections 2-5-72 and 3-9-5B, Florida Building Code violation 105.1, an International Property Maintenance Code 304.13-1 exists on the related property. I hereby adopt the recommendation of the Code Enforcement Board, and the property owner shall have 30 days from the date of my order to clear the zoning violations and apply for and obtain all necessary permits and to bring the property into compliance with their International Property Maintenance Code. I'm assessing a $100 a day fine with a 2-year cease and desist order for the zoning violations, and granting the request for abatement should become necessary. Agenda item Article 9, case R COD 14-01027, John Balmer, property address 156 Deerfield Avenue, Port Charlotte, Florida. County ready to proceed?
Yes, Officer Bush.
My name is Charlie Bush. I'm a certified code enforcement officer for Charlotte County. 156 Deerfield is zoned RSF 3.5, and the owner of record is John Bumbler. On April 28, 2014, based on a complaint, I conducted an inspection of the address and observed the following violations: a semi and trailer in a residential area. During the investigation, I took photographs of the property on April 28, 2014. These photographs fairly and accurately represent the conditions I observed, and I would like to offer the photographs into evidence as Charlotte County Composite Exhibit 1.
We have the wrong case number on that.
On,
Yeah.
you mean up there?
Yeah, up there's wrong, this is right.
Just want to correct that on the screen. We have the wrong case number. It should be COD 14-01027. What do I do with the photographs he just gave me here? I got them in my hand.
Thank you.
I hate that when that happens. All right, Exhibit 1 has been marked County Composite Exhibit 1. No objection, as the property owner has not appeared. It'll be admitted into evidence. You may proceed.
A code compliance was left at the residence outlining the violation and allowing 5 days for compliance. I conducted a reinspection on May 2nd, 2014, and observed that the semi and the trailer were gone, but I'm asking for a cease and desist so it won't happen again. The notice of violation was posted in according to Chapter 162, and the respondent was given 10 days to come into compliance with reference to the existing violation. On August 28, 2014, I conducted the final inspection, finding no semi at the residence.
Anything further from the county?
County requests that respondent be found in violation of Section 3-9-91 of the Charlotte County Code and be given 15 days from the date of this order to clear the zoning violations or thereafter face a fine of $50 per day for each day the violation is shown to exist, and for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
All right, Charlotte County versus John Baumler, case COD 14-01027. Find that the unrefuted evidence establishes the existence of violation of County Code Section 3-9-91, present on parcel 402227385018. I hereby adopt the recommendation of the county. The owner shall have 15 days from the date of this order to clear the zoning violations. I'm assessing a $50 a day fine and issuing a 2-year cease and desist order for against the continuing zoning violations and granting the requested abatement should it become necessary. Next case under new business on the agenda, S. Let me make sure. Case COD 14-01419, Mark Pollock. Property address 22485 Astor Avenue, Port Charlotte, Florida. I note that the owners are not present today. Is county ready to proceed?
Yes, Officer Bush.
My name is Charlie Bush, and I'm a certified code enforcement officer for Charlotte County. 22485 Astor Avenue is Zone 3.5, and the owner record is Mark Pollock. On June 11, 2014, based on an investigation, I conducted an investigation at the address and observed the following violation of high grass. During the investigation, I took photographs of the property on June 11, 2014. These photographs fairly and accurately accurately represent the condition I observed. I would also like to offer the photographs into evidence as County Composite Exhibit 1.
That's all right. All right, I'm in receipt of the proposed exhibit marked as Charlotte County Composite Exhibit 1. The proper foundation being laid there, hereby admitted into evidence. You may proceed.
Notice of public nuisance outlining the violation and allowing 10 days for compliance was posted on the property. I conducted a reinspection on June 25, 2014, and observed the grass remains high. Notice violation was posted in accordance with Chapter 162. The respondent was given 10 days to come into compliance, referring to the existing violations, and on August 28th, I conducted the final inspection, finding the grass not being maintained.
Anything further from the county?
County requests that respondent be found in violation of Section 2-5-72 and 3-2-115 of the Charlotte County Code and be given 15 days from the date of this order to clear the zoning violations or thereafter face a fine of $50 per day for each day the violation is shown to exist, for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
Okay, case Charlotte County versus Mark Pollock, case number COD 14-01419. I find that the unrefuted evidence establishes the violation of Section 3-2.115 on parcel 40222348108, adopting the recommendation of the county, ordering that the property owner that cleared the zoning violations within 15 days of the date of my order. I'm imposing a $50 per day fine. I'm granting the requested 2-year cease and desist order and the abatement should it become necessary. New business agenda item T, case number COD 13-01454, owner Justin Burbridge, property 20528 Tappan Z Drive, Port Charlotte, Florida. I note that the owner is not present. Is the county ready to proceed?
Yes, Officer DeVolk.
My name is Daniel DeVolk, Certified Code Enforcement Officer with Charlotte County. Following testimony applies to 20528 Tappan Z Drive, Port Charlotte. Zoned RSF 3.5. The property owner of record is Justin Freeman Burbridge. On July 8, 2013, I conducted an inspection at this address and found the house was vacant and a blue tarp covering the roof. During my investigation, I took photographs of the property on November 14, 2013, March 7th, May 6th, June 6th, June 25th, and July 7th of 2014. These photographs fairly and accurately represent the conditions of the property as I observed it. And I would like to offer those photographs as evidence. County Composite Exhibit number 1.
All right, I've received the proposed Charlotte County Composite Exhibit 1. There being no objection, it's submitted into evidence. You may proceed.
On 8 occasions between September 16, 2013 and February 21, 2014, I exchanged emails with agents and managers from Safeguard Properties concerning these violations. On June 9, 2014, I posted the amended notice of violation, notice of hearing on the property in accordance with Florida Statute 162. On June 25, 2014, I conducted a final inspection finding the roof remains in violation. And on July 7, 2014, I posted a notice to continue the case to this hearing September 3, 2014, in accordance with Florida Statute 162.
Anything further from the county?
County requests that respondent be found in violation of Section 304.7 of the International Property Maintenance Code and be given 30 days from the date of this order to bring the property into compliance with the International Property Maintenance Code, or thereafter face a fine of $50 per day for each day the violation is shown to exist.
Okay, Charlotte case, Charlotte County versus Justin Freeman Burbridge, case COD 13-01454. I find that the unrefuted evidence establishes violation of the International Property Maintenance Code, Section 304.7, exists on parcel 4022284-85013. The owner is hereby adjudicated guilty of that offense. I ordered that he has 30 days from the date of this order to bring the property into compliance with the International Property Maintenance Code and assess a $50 per day fine. New business agenda item U, case COD 14-00288, Philip Eman, deceased, and Amanda Eman, property address 431 Keyser Street, Port Charlotte, Florida. Is the county ready to proceed?
Yes, Officer DeVolk.
Again, my name is Daniel DeVolk, Certified Code Enforcement Officer with Charlotte County, Florida. Following testimony is for 431 Keyser Street, Port Charlotte, Florida. Property is zoned RSF 3.5. The property owner of record is the deceased Philip G. Eman and Amanda L. Eman. On July 8, 2013, based on an anonymous complaint, I conducted an inspection of the property and found the house damaged by fire, the roof missing, broken windows, assorted junk around the property, and a van on jacks in the driveway. During the investigation, I took photographs of the property on February 14th, March 27th, April 9th, June 25th, August 21st of 2014. These photographs fairly and accurately represent the conditions of the property as I observed it, and I would like to offer those photographs as county evidence, composite exhibit number 1.
I'm in receipt of the proposed exhibit. I've marked it Charlotte County Composite Exhibit 1. There being no objection, they're admitted into evidence. You may proceed.
On August 21st, 2014, I posted the amended notice violation notice of hearing for the September hearing on the property in accordance with Florida Statute 162.
Anything further from the county?
County requests that respondent be found in violation of Sections 3-9-61 of the Charlotte County Code, Sections 108.1.5 sub 3, 304.2, 304.4, 304.18.1, and 304.18.2 of the International Property Maintenance Code. Be given 30 days from the date of this order to clear the zoning violations and bring the property into compliance with International Property Maintenance Code, or obtain a demolition permit to remove the structure from the property, or thereafter face a fine of $50 per day for each day the violation is shown to exist, for the entry of a 2-year cease and desist order for the zoning violations, and for the matter to be referred to the Board of County Commissioners for abatement in the event of noncompliance, and for the cost of any such abatement to be added to the fines.
Thank you. Charlotte County versus Philip Eman and Amanda Eman, case COD 14-00288. I find that the unrefuted evidence establishes the violations of Charlotte Code Section 3-961, International Property Maintenance Code Sections 108.1.53, 304.2, 304.4, 304.18.1, and 304.18.2 exist on parcel ID number 402-102-478-011. Therefore, adjudicate the property owners guilty. And I accept the recommendation of the county and hereby order the owners to clear the zoning violations, to bring the property into compliance with the International Property Maintenance Code, or to obtain a demolition permit to remove the structure from the property within 30 days of my order. I'm assessing $50 a day fine, granting the request for a 2-year cease and desist order for the zoning violations, and granting the requested abatement should that become necessary. In terms of new business, I believe that concludes the agenda. Next item on the agenda is staff and citizen input on any subject. Do we have any input from anyone? There being no staff or citizen input, I'm going to go ahead and adjourn today's proceedings. Thank you.
Thank you.
Hey, Sheriff, we have a question. about why your office, your intelligence division, is investigating private citizens for criminal investigation that happen to be activists that are overseeing your department. Why would you have your intelligence division investigate private citizens? We have done... Sir, we don't hate anyone. We love freedom and we love American people. And government is out of control. That's why you're seeing such a revolt nationwide. Why can't you just answer, why is Susan Edwards, your intelligence division, investigating private citizens? This should not happen.
Are you here to apply for a job?
Possibly I might be applying for a job, but that's irrelevant to my question. Why would you ask that question?
Well, enjoy the fair.
Okay.
Excuse me.
Excuse you?
Excuse me, sir.
So those of you that haven't
Wow.
been on a bike before, we're
Sheriff's
just
getting a little too pushy.
is
You
the
work
hard
for
part.
us, Sheriff. Just keep
keeping
that in
in-
mind. At one time, we respected you, but not with that type of attitude.